Yes, sir. We are live on YouTube as well as on Zoom. Good evening, participants. Welcome to the live session of the course Understanding Competition Law, Theory and Practice. Our instructor, Professor Mayank Pratap, sir, is here with us. Kindly feel free to join in and clear all your doubts. So students are yet to join directly on Zoom, but we received few questions via Google form. Would you like to take those questions first, sir?
Sure.
Yeah. So shall I repost those questions on the Zoom, or should I read out the questions, sir?
You can read. You can read
Yeah,
out.
yeah, sure, sir. Sure, sir. I will also screen share, sir, so that you can view those questions. Just a second. Sir, are you able to view my screen?
Yes.
Yeah. So the first question is from Mr. Somesh. And the question is, how do practices like tying and bundling harm competition? And when might they actually help consumers? How difficult is it for smaller firms to prove denial of market access against large corporations in practice? Two questions are there, sir, in this one.
Yes. Okay. So let me start with the first question. That is regarding with the tying and bundling. The question is like tying and bundling, how this is harmful and harm for competition, and when might be actually help consumers. Actually, what is tying? If you see the anti-competitive agreement practices, there are certainly two type of agreement: vertical and horizontal. And tie-in agreement is a specific type of agreement which includes any type of agreement which requires the purchaser of goods. That means as a condition of such purchase to with other goods, like where the supplier makes the supply of one product that you may call the tying product, and conditional upon the buyer that distinct separate product. That means there are two separate products where the uh, purchaser or seller taking the advantage or taking the leverage of selling the one distinct product with the required product. So this type of the agreement is called tying and bundling. That means there are two distinct products in absence of tying. It can be purchased from different market, and the problem is how this is harmful for consumer, because actually the anti-competition law practices, they restrict or prohibit the any type of practices which is harmful for market. And the basic requirement of consumer, or the ultimate object of this act or any type of consumer protection of act, the promotion of competition and providing the better opportunity regarding the purchasing in the marketing to the customer, so that this is not a good practice where buyer is not willing to buy a product, but definitely he have to buy the product just because he have to purchase some one product. Suppose you need a gas connection, but if there is a pressure on you being a customer that you can only take the gas connection until unless you take the burner, that means stove with that gas connection, that is like the putting the burden and additional purchasing with the requirement of gas connection. So definitely this is harmful, and this is not only harmful for the competition, but rather this is also very harmful for the customers and consumers choice. There are so many cases what we have deal with the course. In fact, if you go through the slides and go through the lecture of the particular topic, you will find the course, the cases like the United India versus United States, like versus Microsoft Corporation, and there are so many other cases where you will realize that how this type of practices is harmful not only against the competitive market, but against the consumer's choice. So in that sense, this is harmful towards the customers and consumers as well as competition. One students have asked the question, hello sir, what are the most important difference between the global competition law regime and Indian competition act. See, basically the Indian competition act is, you can say, the genesis of the competition or antitrust act is comes from the US law, no doubt. That means this is the origin of the competition act at the global platform, you can say. That is US law, or the Ceremon act was the first anti-competitive segment in that case. And if you come to the India, there were no such type of act initially, apart from the MRTP Act. But Indian MRTP Act was very much different, and the difference is it is just for the restriction and regulation of monopoly behavior, which was very much restricted, and there are so many exceptions, like the government companies are with the exception with this act. But if you see the competition law, Competition Act is an act which promote the competition. And if you go through the some recommendation of structure committee, and again the unfair trade practices, and there are so many cases even in India, you will find that there are so many impact and approaches which are aligned with the US, EU, and US and European Union case law, but somehow, certainly, the Indian Competition Act is different from the US and EU, European Union, because the basic nature of Indian competition law is in the promotion of competition, keeping in the mind the ultimate stakeholder, the interest of ultimate stakeholder, that is consumers. That means in under Indian competition law, the regulating body, that is CCI, is, you can say, the more powerful in context of its jurisdiction. Like if you go through the section 32, and regarding the investigation or inquiry with the help of DG under section 18 and 19. So there are so many broad category of investigation and inquiry. Anyone can be informant or can inform, that means as a complainant, or the CCI have the authority. And the impact of this type of the uh, act, what the Indian provisions are here, there are so many others remedies which are available. No doubt there are also the approaches are with EU, but the at practical aspect, the lenient and the competition advocacy, and there are so many other phenomena and the dimension of the Indian Competition Act, which makes it more suitable and more strong in the context of interest of stakeholder and consumer. And one more important thing, for consumer welfare, there is one other act, that is Consumer Protection Act in India. So in align with the competitive environment, competition, and consumer behavior and consumer welfare, the Indian competition lies slightly different with the various approach in the interest of consumers. Uh, the question is, like one student asked, that why is appreciable adverse effect on competition such as crucial concept in identifying anti-competitive achievement? Could you explain with example how court in India apply per se rule versus rule of reason? Yes. No doubt, the per se rule or rule of reason, both are actually only the rule of interpretation under the context of anti-competitive environment or anti-competitive practices. Basically, the actual purpose is to identify if there is any anti-competitive behavior exist in the market or not. So that there are two type of practices which are prohibited in India, that is horizontal practices and vertical practices. But if you go through the act, the provision, that is section 3 subclause 3 and section 3 subclause 4, section 3 subclause 3 is about the horizontal understanding or the agreement. There are some illustrations, some examples, or some event where prima facie the agreement is against the market or environment, so that we are applying the rule of per se. That means apparently they are against the anti-competitive or anti-competitive behavior. And second one, that is the rule of reason. Rule of reason is basically the rule of reason of interpretation, where you have to construct, where you have to construct the, where you have to apply your mind, where you have to think and interpret the both side. That means the both side of coin, that is in what are anti-competitive and from the approach of pro-competitive. So basically, the Indian courts applying both rules in various cases, like if you remember the cases what we have also discussed in the case in the topic and under the lecture, the more important case like tire, if you remember the tire case, or Mahindra and Mahindra Limited versus Union of India case. That means after making of reference, if you remember the Tata Engineer case, where the judiciary, the Indian judiciary had applied this type of cases. Basically, see what is happening here, because there are both aligned, or there are both approaches may be tried. Firstly, you have to identify or what is your approach. The approach is, the problem is, and the challenges is, that is only one. You have to prohibit, you have to restrict any type of anti-competitive environment or any competitive anti-competitive businesses. For that purposes, every type of agreement does not means it is anti-competitive. There are so many events, there are so many situations, and there may be some type of challenges from small enterprises to big enterprises. There are certain enterprises which may take leverages. There are some enterprises like the startup which have to put all the efforts for the purpose of business, so that there may be chances not only to the act which is anti-competitive, but they are for the purpose of their promotion, or they are for the purpose of their business strategy. Just if you take an example, if a mobile company, suppose if a branded mobile company flow its all the goods, that means the mobile phone, in a specific territory of the market in a showroom, just tie up with a showroom that this showroom will only deal with such type of, that means you can say exclusive supply this type of the mobile phone for this particular. Prima facie, you can say this is like the anti-competitive because all other brands are prohibited or restricted with the market. But see, the problem is the stock, the percentage, the market, the coverage of market, the important aspect. You have to deal with section 19 subclause 3 and 19 subclause 4. You have to see what is the percentage, what is the actual stock in the market. And if there is a no significant market dominancy of a product, so at that market, a small player, if like this type of activity, put their effort to promote the businesses, in any specific area, any geographic area, or any specific market. It is just like the strategy, or it is like the promotion. So you have to apply the rule of reason. And not in a single case, but there are so many cases where the Indian judiciary have applied this type of agreement. Like if you again remember what we have already discussed, like the Sonam Sharma versus Apple case, and again the Consumer Guidance Society versus Hindustan Coca-Cola beverage case, where Hindustan Coca-Cola under Section 3, subclause 4, appointed the preferred beverage provider. Suppose in a cinema hall, in a multiplex, if you go through and if you find there is only one beverage available, it just not means that it is an anti-competitive agreement, because one beverage and the agreement for the against the customer, because they are providing only one kind of beverage. You have to see, you are pressurized to take that particular brand or not, or if it with some other condition, if it is not tying and bundling with the tickets, if it is not like the pressure, you must take such type of product. So it may be possible, because you are free to go market and take any other brand, but particularly at that time, at that market, CCI examined in the case, the agreement and the market condition you have to examine. And if there are so many players in the market, so That means there are so many intense competition, and any multiplex owner, like any cinema hall where you can find this type of activities, been switching over their supplier periodically by rotation, by chance, 3 month, 4 month. So this type of agreement for the period of 4 months, what was in the condition of this particular case, what we are discussing here. So it is the lack of dominancy. So you have to see with all type of the element, so that you may only interpret, and you can find a conclusion that where it is anti-competitive or not. So no doubt both anti-competitive approaches are important, where you have to examine with the anti-competitive approach and pro-competitive approach. But definitely there are some appreciable adverse effect, like which is prima facie agreement, and there are so many prima facie activities which is at the prima facie event, that is feel like yes, that is very anti-competitive, so that you have to apply the per se rule. And again, there are so many questions regarding this which we have already discussed in the one more important thing are the agreement that might seem anti-competitive on the surface, but actually benefit consumer in long. Yes, this is very important question. There are so many agreement, that are so many uh, understanding on, and maybe that on the surface, which may seems like the anti-competitive, but actually may be a beneficial to the long. But the thing what you have to examine, you just keep in your mind, the Competition Act is very much different from the Consumer Protection. You have to examine the Competition Act not with regard to the consumer approach. Actually, you have to take all the focus from the perspective of the competition. The actual potential of this Competition Act is how to promote competition, how to curb anti-competitive practices, and how to restrict or regulate the abuse of the dominant position of any entity in the market. So that there are so many event, understanding, or consent, or practices which may helpful from the perspective of the customer, which is likely very beneficial. But the important thing is, if on the parameter of competitive market, on the parameter of section under the provision of this act, given under section 3334 or 31, if it is like anti-competitive, which is like prohibition, which are given under the provision, or which is like where the person or the entity using or taking leverage of this of their entity. Suppose a big firm having a good stock, good revenue, by this taking the advantage, if he start to selling some goods on minimum price, definitely it will helpful, and it will be the choice of consumer. But how many days? 10 days, 20 days, 1 month, 3 month, 5 month. And what will be the result after spending of some times, passing of some months or period? You will find the small player will drift out from the market, and a time will come where this type of firm will make the monopoly, and there is no guarantee that the price will hike 2 times, 3 times, or 4 times. So at that time, consumer will have no choice. And if you take the vice versa, sometimes it happens like the starting at the starting position, a small player, a good player, a genuine player, the person or the entity or firm with the good quality and good strategy comes into the market, but because of their limitations, they cannot sustain in the market below some specific price. For the price, the other big firm are floating. But at the time, at the market of passing of the time will come when they will renew, when the users will increase, the time will come, they will provide you the that good quality even on reduced price. So at long run, it may be a good choice, and you will find that customer on the basis of quality, on the basis of choice, may switch to that particular big brand to such type of small brand. So uh, it is the matter of the construction, the provision, and the norms and essence of the act. So you have to go through the essence of the act. That essence is you have to see whether there is promotion of competition, where there is not any such type of activity which restrict the competition. And from this perspective, if you see the or the try to equate the approaches or the provision or the event, you will definitely get your answer exactly what you find. So just keeping in the mind, you have to separate your view from the Consumer Protection Act. For the purpose of consumer, there is a specific act, that is Consumer Protection Act, and there are rights are given. So do not confuse with the consumer choice only. No doubt the consumer is ultimately beneficial, but the jurisdiction and the essence of this competition act is not the customers, but the essence of competition or promotion of competition. So from this point of view, you can get your answer. One employee, if I can see, Mr. Sharma, uh, can you give recent example from Indian market where dominant position were abused? Uh, See, there are so many cases where Indian judiciary has dealt with such type of the question. The examples like the dominant positions were abused. The position of dominance, if you see, you have to take the advantage or take the examples of some cases like the Geo Bharti Airtel case. Initially, it was started with the Bharti. If you remember, in the year of 2006, 7 approx, uh, scheme was launched from the Geo. Rupees 501 or 500 rupees, they were providing the mobile phone. The cases were started, and it had took 1 year, 2 year, or 3 year. But actually, what the interpretation and the CCI find out that there was no abuse of dominance, because dominancy is a matter of fact. Abuse of the position is a very, very different and subjective question, and this question arises only in such condition when you establish the dominancy of the market. And from the Indian perspective or the Indian economy of perspective, you will find there are so many players market in the market are private player, and there are very, very few area where one particular one or two important players are there, because in every sector there are so many players. So there is a minimum chances of the acquiring the largest market, that is the making of dominancy. They may be dominance in each and every situation, but the dominancy have to see in such market under the context where you are dealing with. Just like the mobile, it is a mobile is a very mobile industry is a very vast market. There are so many aspects of mobile market, whether it is mobile market, 2G market, 3G market, 4G market, where it is about a spectrum, where it is about data, where it is about the talking, in which manner you are dealing with the mobile market. So the problem is you have to identify the relevant market. The basic question is, that means you have to go narrow. And relevant market, we have, the relevant market means relevant geographic market or the relevant market. But relevant market is become important, and such relevant market, if the dominancy is not proved, however there are so many big brands are there, they are indulged in such type of activity which prima facie looks like that they are abusing in market, but due to the market power, which is the narrow, and the market share, which is spread in more many of the uh, companies, so it is very difficult to establish the abuse of market. But yes, if there are the type of the illustrations, definitely they will curb and sit under the provision of this section.
Thank you so much, sir, for answering all the queries raised by the students in a very detailed manner with examples. So far, nobody have joined the session, sir, and on YouTube also no posts are there. So, apart from discussing these questions, would you like to discuss anything in general, sir, related to the subject?
Uh, Actually, under this topic, under this paper, we have this uh, course is deal with a such manner where not only the student but the person who is working or in the position or the is not from the law field, that means from the commerce, or the person who is just graduate or 12th, or the that means after completing their schools, if he is in market field, he may join this course. And if he go through the lectures, he will find that there are two approaches from the course as deal. The first is the academic approach, which is important from the students, and the second is practical approach. So I just want to convey one message. If you are a student, you have to go through the provisions, the theoretical aspect of this academic curriculum for the purpose of this course. But if you are just curious to know about the market and competition law, or what is going on in the market and what is the impact of market, you have to go through the provisions, but we have deal with the practical examples, case law, and the illustration which I have covered under this and the various topic of this. So with this, I just wish to convey to all the curious students, just go through the topics well versed. It covers all the aspect where I have tried my best to convey about this subject.
Thank you very much, sir. Since there are no questions, can we wind up the session, sir?
Yeah, sure. Thank you.
Yes, sir. So thank you once again, sir, for this live session. It was very informative and helpful. We hope our learners watch the recorded session and benefit from it. We are closing the session now, sir.
Thank you.
Thank you, sir.